Good morning, everyone. My name's Helen McIntosh, and I'm the president of the South East London Chamber of Commerce. I'm really pleased that we have today's webinar taking place because we're going to learn, I think we've all slightly forgotten or put it on the back burner about GDPR, but we're going to learn today about how to navigate it. So, compliance essential and good practice, that's what we want to have. And our guest speaker today is Michael Pope, who's a solicitor at Grant Saw Solicitors, and is a great expert on company, commercial and employment law. You'll see Michael has a very deep knowledge, which he'll be squirreling down into to give us insights, on this very complex subject of GDPR compliance. I think there are a lot of myths out there. And Michael will tell us later, but there will be some information that will be sent out possibly next week. So you'll all become experts on GDPR. We're going to have questions at the end. So I hand over to Michael.
Thank you very much, Helen. So I think we're just bringing up the slides, are we? Sharing the screen. Okay, next slide. We're just bringing up the next slide, I think, which is going to tell you about me. I'll tell you about me in the meantime, which is that I am, as Helen says, a company commercial and employment lawyer in what we call our business services department at Grant Saw. And what that involves is company work, corporate work such as mergers and acquisitions, and that in itself involves quite a lot of GDPR in the due diligence process. On the commercial side, it's very rare now that I draft a contract that doesn't have some data protection or GDPR provisions in it. And on the employment side, I come across GDPR to a very significant degree, particularly in employment disputes, where what we're going to talk about a bit later on is the data subject access request, and that has become the weapon of choice for employee solicitors when they are bringing employment claims. So I'll talk about that in some detail. So those sort of areas of my practice all feed into, or GDPR feeds into them. So next slide. What I'm going to do is give you, first of all, a very brief overview of GDPR and its significance in the UK and in the legal system, the importance of compliance and good practice, and then we're going to have a step-by-step look right across the spectrum at where we need to comply in relation to GDPR. It's all about compliance really today, and the reality is that there is a huge amount of compliance required in relation to data protection. Most people are aware of that. Most people are aware of the general rules and concepts, but I don't know the levels of knowledge of everyone that I'm talking to today, but I hope I'll be able to offer you all something of interest, whatever your level of knowledge. As Helen mentioned, I'm going to do a detailed handout. I think the slides might be issued first, but I'm going to do a handout explaining the detail and putting in links and so on to documents that we're going to talk about. So that I'll try and have that out next week, and also suggest some form of report or compliance assessment that we at Grant Saw might be able to offer attendees today, if having heard me, there are things that you want to follow up on. So next slide, Michael, please. Really the thing to do is to set the scene and the landscape, and a key player in all of that is the Information Commissioner, and that really is a significant element of what we're really talking about, because they are the regulator and the person that we are concerned to keep on the right side of, but also to bear in mind that they're a bit like an ombudsman. The ombudsman services have sort of transformed the ability of people to bring claims quickly and cheaply. They used to have to go to the county court or some other legal route. That's all gone a long time ago. But the thing is that it's all free, and the people who want to complain have really nothing to lose. They can sit down, write something, and the whole thing is set in motion. So the information commissioner is, it's really fundamental to all of this. The courts do have a role. There are data protection cases going through the courts, but that's an expensive process and time consuming, it's uncertain, it's risky. So it's really only the key cases that reach the courts, but they do have a role to play. The whole thing, the whole of the landscape, if you like, is really covered by the concepts of personal information in what is an information society. Things obviously now have changed so much since computerization got going, really, I suppose, in the early 1980s, that we need a system of regulation for all of this. People often sort of talk about the internet as the Wild West, but in reality, it is regulated, and certainly all the technology is regulated. And we're going to talk about how that impacts in relation to GDPR as well. So that's the brief introduction. Next slide, Michael. Thanks. So personal data, you probably know that personal data is anything that identifies a living human being, whether it's direct or indirect. The categories, the types of personal data are really almost indescribable. There are so many. You can look at things from a person's internal perspective, their knowledge, their beliefs, their preferences, what they like to do, all of those things. You can look at external information, which identifies them, name, user numbers for things, and so on. You've got ethnicity, you've got people's sexual information, their preferences and so on. You've got behavioral aspects, what people do with their time, whether they, like to browse the internet and go shopping on the internet, that sort of thing. Demographic information, medical and health, physical characteristics, financial information, social information, professional stuff. I won't, you could go on for 20 minutes just trying to map it all out. Next slide. There is a distinction you probably know about between ordinary personal data and sensitive personal data. There are specific things that need to be treated more cautiously and more, in terms of processing, in a more limited way. And these are largely the person's racial or ethnic origins, their political opinions, their religious or philosophical beliefs, trade union membership, and genetic data. And we'll talk a little bit about how that needs to be processed a bit later on. So, in terms of we've just talked about the categories of personal information and sensitive personal data. It has to be in some form of filing system, but that really covers pretty much anything other than random pieces of paper that have no obvious connection to another piece of paper. So obviously computer systems, but it can also include documents, physical documents in a ring binder, in a file, something of that kind. Possibly even notes in a notebook if that's connected to other documents. So the first step in compliance is identifying and finding where your data, personal data actually is. Where are you processing it? Next slide, please. So that really involves a process of data mapping, asking first of all the question on what are the types of people, what are the categories of people on whom we hold personal data. So very commonly, it will be for an employer, it'll obviously be the employers and workers, the job applicants and people who used to work for them. On the customer side, on the supply side, rather, there'll be service providers, consultants, contractors, that sort of thing. And on the customer side, there'll be obviously customers and clients or service users, depending on the kind of business organisation. Lists of prospective customers and former customers and so on. So that's the question is, where is this personal data actually held? It will be for customers, obviously it'll be in lists, it might be in email correspondence with them, it might be in email correspondence with third parties like suppliers and so on. Certainly there will be correspondence with employees. There'll be the employee records, there'll be the payroll information, financial information, and the business records. So the other key element that we're going to touch on towards the end is data security. And that will obviously really depend on, again, the nature of our business, what sort of systems we have in place. Most information is now held electronically and it's vulnerable. You know, it's the protection of personal data that you need to have in mind. It's really a question, I think, again, of identifying your systems. You know, do you have cloud-based systems? Do you have your own server? There aren't as many local servers, I think, in action as there used to be, but you may have data at that level. You will have laptops and possibly desktops. May very well have personal devices which have personal data on them relating to the business that's processing it. So, you know, an identification of where all the data is a starting point. Thanks. So, why does this matter to you? Well, clearly the downside impact of things going wrong is really important. The trouble is really the speed and the scale at which things can escalate. So you might be looking at something that, in one respect, you might think, oh, it's a bit annoying to have to deal with this, but it could get serious very quickly. It can go to the point really of an existential threat for some businesses if there's been a cyber breach for which it's responsible. So the starting point really is work backwards, I suppose, from the the doom-laden message of the risks. So you look at the potential for fines. The fine regime is very significant. You've heard a lot about very large fines, very large organisations, but there's plenty of much smaller fines for smaller businesses and organisations. You can factor in the cost of investigating what's been going on and possibly court proceedings. Criminal offences can be committed. Loss of customers and contracts if the reputational side of this gets engaged, and you've got this overhead of internal management time. So we could put in dozens of hours of time when someone should be getting on with something else, trying to sort all of this out. So the way really to start the process is to look at the profile of the business, nature of the business, the amount of personal data that the business is processing, the categories of personal data that you're processing, the integrity, competence, and level of preparedness of your staff. To talk about that, businesses and organizations are entirely dependent on their staff in this situation. And are they as committed and as aware as they should be of what they need to do in situations where there's a risk if compliance isn't properly managed. So we'll talk about staff training in a bit. And obviously it's dependent upon how well organised we are, and do we have the policies and procedures in place, and are we implementing them. So I'm going to just really run through the spectrum now on the key elements of GDPR which require compliance. And they start with accountability. We'll then look at leadership and oversight. We'll look at policies and procedures, training and awareness. We'll look at individual rights, which is a key part of this, transparency, records of processing data on a lawful basis, contracts and data sharing, international transfers, security, breach, and breach reporting and monitoring. There's a lot in there, but I'm going to run through them quick, and I'm going to focus on the documentary side of this, because it is really documenting processes and documenting decision making that's really at the core of compliance. So in each case, I'll suggest what the documentary position is or should be. So starting with accountability, accountability is a key principle under the UK GDPR, because it isn't just really about doing it, it's the ability to demonstrate that it's being done. And the ICO has published a framework for accountability, which assists organisations in ensuring that it understands and is operating a system of accountability. In terms of the documentation, there is the ICO document, the accountability framework. I'll put a link to that in the handout. They have also produced a document called an accountability tracker. You might be familiar with that, but I'll link to that too. I think a good document to have is an accountability questionnaire for the organisation or management to do some of its own assessment of its own particular way of doing things. I think you should think in terms of the responsibility that the organisation has for its suppliers and people that are processing its data. So I would suggest a supplier audit from time to time is worthwhile. And I mentioned a little earlier on that I do M&A work and mergers and acquisitions, and we come across data protection as a core element of that process of due diligence, where quite often it can be one of the most important elements in the transaction, because a buyer will be very concerned if it's not satisfied that it can get a complete picture of the position in relation to the organisation that it's buying and what its data protection compliance levels have been. So the second thing is leadership and oversight. The ICO notes that strong leadership and oversight is fundamental to accountability. While some organisations are obliged to have a data protection officer, I don't know if there are many data protection officers here, but that's not a mandatory requirement in a lot of cases, but you've got to have somebody who is in charge. There's got to be a process of control and identification of who is doing what. I think that really for many organisations, a good starting point is to have some documentation at board level. That's always really sort of central, if you like, to the process of cascading responsibility down through the organisation. It's the board that ultimately runs the company. It's the board that's ultimately, the directors who are ultimately responsible for these decisions. So I think board minuting of the data protection process is important. I think a board memorandum, a report from whoever it is that's advising them, solicitors or data protection specialists or someone from within the organisation should be producing something on which the board can rely, and the board should be reviewing data protection on a really regular basis, whether it's quarterly or whether it's annually. There should be evidence that it's the controlling mind of the business is actually looking at this. I think a data protection job specification is absolutely fundamental. Whoever is doing the job or whoever has data protection as part of their job responsibilities, that's got to be put down in a clear way so that we know who's responsible for what. If you've got an outside provider for your data protection services, then you'll want a consultancy agreement or a supply services agreement with them, and that will document their responsibilities. That should be good. So it's the next one. So policies and procedures. The ICO notes that effective data protection policies and procedures can help an organisation to take the practical steps required for compliance, but the scope of those policies will vary very significantly. I mean, that's absolutely true. Everyone's got slightly different policies, and everyone's got a slightly different take, I think, on most aspects of it. But I'll just show you the main policies that I have in mind. So I think everyone obviously needs a data protection policy. They need a data retention policy. Data retention really is very important. Social media, IT and communications policy. We need a CCTV policy. I think if you've got CCTV or monitoring services, you've got a home working policy. I think you should do that, bearing in mind that data protection obviously flows into the home working environment. We don't need two IT and communication systems policies. Sorry about that. Bring your own device to work is very important because data, if you're using your own device and data, personal data of the organisation is on there, then that is part of the system. And an AI policy, I think it's becoming increasingly important. So training and awareness, the ICO notes that employee training on data protection and the organisation's privacy programme should be up to date, relevant and accurate, and that training and awareness is key. So, it varies really from one organisation to another as to what they want to train on. I mean, a lot of people buy these services online. It's really a range of things that might be interesting or might be necessary for people at different levels within the organisation. It may be that for some people a key message kind of approach is sufficient. For others, you might want an in-depth level of presentation so that they really understand the nuts and bolts of it. Information and cybersecurity is pretty fundamental, I think, to most businesses. We all have to do that. Don't we, Michael? I think we do. Yeah. Documents and record management training for those that are responsible for documents. And of course, recording the fact that the training's been given and kept up to date. this is increasingly important. It's important, particularly in employment law now, in areas such as discrimination. The training is absolutely fundamental to the employer's ability to defend itself and justify itself when problems emerge. So, privacy rights. Obviously, things will depend to a large degree on what kind of business you are, what kind of systems you have, and what kind of contact communication you have with people, whether it's face-to-face, telephone, video, electronic. It's probably all the things. And that is handled at one level by privacy notices. Most people are pretty well drilled in that. But it's important that those documents are in place for whatever purpose, whatever environment they are addressing, whether it's online, whether it's offline, and certainly for employees, workers, and contractors, there must be privacy notices to say what it is that's being processed and what's been done with it. Then the other side of the coin is really very, very important, and that is subject access requests and subject access rights. The starting point is to look at what it is that people have as a right in relation to the data that's being processed about them. So they have the right to receive information about the controller's personal data and processing activities. That's largely done through the privacy notice. They have the right to access their own personal data. That really is the key to the thing, and that I'll explain in more detail in a minute. You'll possibly will have come across a data subject access request. The right to have the data corrected and the right to have it erased if necessary, if they want. They have the right to restrict the data that's being processed about them, or to object to having data processed. They have the right to receive notification about data security breaches. We'll talk a bit about that at the end. We've talked about the right to receive the data itself, and there are restrictions on purely automated decision making when that can be done. So the responsibility of the controller in terms of the data subjects' rights are, clear, set out here. They include communicating with data subjects, responding to subject access requests, handling data portability requests for transfers, and so on. There may be shared responsibility between controllers. And again, there's a restriction on automated profiling. The processing, there is also, like I said earlier, the position with regard to data breach and the requirement to be transparent about that. So in terms of the dealing with subject access requests, I think the documentation and procedures is really key. It isn't just a question of sending an employee or whoever it is, customer who makes a subject access request, a lot of documents and hoping that that's enough, that will shut them up. You've got to do a lot more than that. You've got to establish what you've got and why you've got it and how long you're holding it, and you have to tell them that. So you have to start by identifying, like we were talking about earlier on, about the systems. What is it that we've got? Where is the data? Where are we going to search? What are we going to search on? to find the data for these individuals. We've got to cover everything, the cloud-based systems, we've got to cover the internal data, we've got to cover the devices, the handheld devices, that sort of thing. So it's very challenging, very demanding. We've got at the same time, of course, to keep an eye on other people's data subject rights, other people whose names turn up or can be identified from documents that are being disclosed. They may have to be redacted, or they may have to be asked for consent. In fact, the starting point is to ask them for consent. I'm not very sure that anyone ever does. There's a lot of redaction done in these things, but it's all very time consuming. You've got 30 days in which to do this, although employers or data controllers have the right to extend their own time up to 3 months if they want to. But they have to justify that, and quite often that in itself causes a bit of a row, and it can be challenged. We see a lot of data subject access requests, as I said earlier on, in relation to employment disputes. And I would say probably now about 25 or 30% of the settlement agreements that we do have a clause in it which says that the subject access request should be cleared off. In other words, the employer does not want to answer it, either because of the time and effort in doing so, or because there's something in there they don't want the employee to see, and it's a criminal offence to delete data or refuse to provide data in a dishonest, or to do something dishonest to hold back personal data. So they don't want that to occur, and they get the subject access cleared off by the settlement agreement. I have to say, I'm not sure about the law on this. I don't know if there's been a case. I haven't found one in which that's come before the courts. But can a subject access request actually be cleared off? And can the right to deliver another subject access request at a later stage, can that be cleared off? It's the sort of thing that I think it's very likely that the courts will have to give some guidance on. But at the moment, it's really important. It's an important part of a settlement. It probably governs the negotiation of the financial package that the employee receives, because of the impact of having to carry on otherwise from the employer's point of view. So transparency, the ICO again noting that this is a important fundamental thing, but it's largely what we've been talking about in terms of awareness of the data protection principles and communicating with the employees. So the privacy notice is the subject access requests, and the upfront communication of data breaches. Those are things that really govern transparency. So the documentation really is, again, what we've looked at there. The privacy notice is the communication of the data subject rights, and the communication of the data subject data, and anything that has gone wrong, like in relation to that data, notification of that. The records of lawful processing. Organisations are required to document their processing activities. The ICO can require to see these records. The ICO says, well, that will obviously help to improve information governance and compliance. I think in any situation, documenting the process is fundamental. Just a quick look at the principles of lawful data processing. I think everyone's sort of reasonably familiar with these. The need for lawfulness, fairness and transparency in the data, limiting the purpose of processing information, data minimization. Accurate, obviously it's got to be accurate, and it can be challenged if an employee gets their, or say an employee, a data subject gets their information and says this isn't right. That's it's a right to have that corrected. That could lead to a dispute. Storage limitation, how long are you going to keep it for? Integrity and confidentiality, don't lose it, don't get hacked, and accountability that we've been mentioning. I think everybody also knows that we're going to process data, personal data, you need a basis for doing that. And it'll be one of consent, contract, something in the contract that entitles you to deal with the data, a legal obligation, a vital interest, a national interest, I suppose, a public task if it's a public organisation, and legitimate interest, which is a key player in all of this. So consent, I think consent seems to be an easy justification, but it's got to be freely given, and often the problem with consent is the imbalance in the relationship between the parties. If it's an employment relationship, it's the employer that really holds the cards, and it's more difficult for an employee to stand out or hold out against that and say, well, I'm not doing that. So it's a question of, is the consent free? Is it genuine? And is it informed? Has the person really understood what they're giving, what consent they're giving? So if you're obtaining consent as the basis for your processing, it's important to say who you are, why you want the data, what you're going to do with it, and that the individual can withdraw the consent at any time. That's us. So the documents that you're going to have are going to be a record of the processing activities of your data controller, or a record of the processing activities of your data processor. You will want to have, I think, a legitimate interest assessment. So the things we've just been talking about, particularly the legitimate interest factor is very important. I think probably the majority of people are relying on legitimate interest. An employer has a legitimate interest to process data relating to their employees in terms of their financial information, so that's payroll, appraising the employee's performance, keeping personal records relating to them, and so on and so forth. And an information asset register, sometimes identifying what your information assets actually are. That is also a useful document to have in the context of establishing what your data processing is and recording it. Then we've got the data controller data processor relationship. And the data controller, of course, is the person that makes the decisions principally about the data and what happens to it. And the processor effectively does what the controller tells it to do with the data. There are sort of obviously plenty of grey areas or situations where one has to look carefully to see what is actually going on. You must, it's a matter of law, you have to have that relationship documented. And you can also have joint controllers, or you can have part joint controllers, where some pieces of data are being processed by the joint controllers together. Other parts might be controlled by the individual controllers, or it might be that there's a processor involved in that process. So it's important to identify the roles of everybody. And documentary wise, we'll have a data processing agreement. We might have a data sharing agreement, or there are various variations on the theme of what you can do with that. The data processing provision might be part of a wider document, a wider relationship, or so might the data sharing agreement, as we might build that into a document with other things going on, or you might have a standalone document for that. Transferring data abroad. This really is the starting point is to work out what you do with data with you, where if you're dealing with international transfers, you don't need to worry if you're within the EU or the EEA, but there are other countries that are outside that perimeter. Yes. And that all works on the data adequacy assessment of those countries. There's a list of them, and in fact, it's kept up to date. You can find the list. Those have equivalent data protection systems to our own, and there are one or two countries, probably more in fact, that have some adequacy that's acceptable, but don't meet all requirements of it. That all gets a bit complicated. So you should have an ICO, International Data Transfer Agreement, and you should do a transfer risk assessment as part of your compliance process. Just to finish off, data security, we have looked at the fact that obviously the processing of data is largely a technological activity, and it's very important that the risk inherent in that is assessed. The rules really around this are slightly elastic. They have to be, because obviously one size doesn't fit all, and the speed at which technology is developing makes it impossible to have a hard engraved system of doing things in only one way. So the GDPR requires that that security measures of a data controller must take account of the state of the art, so they must be aware of what's out there. They can have regard to the cost of the implementation and so on. But of course, there's a justification argument to be made. There is the cost, something that should be, that is significant, it should be expended where the risk has to be addressed. I mean, that's likely to be the way that the ICO will look at it. If you said, well, we just couldn't afford it, that will ask the question, well, should you be in business processing people's personal data if you're not able to put your systems in place? And what is the impact of the loss of data? How what is the data you're holding, and if that data goes in some kind of cyber breach, what is the downside risk? What is the consequence for the people affected? So looking at the risk side of it, in assessing the appropriate level of security, account must be taken of the risks that are presented by the process, in particular from accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data transmitted, stored, or otherwise. Really, just what I was saying in terms of what are the consequences for the loss of the sort of data you're holding. So the data processor, they come under the obviously under the responsibility of the data controller. So the data controller, has to choose very carefully and make sure that their data processor is going to be up to the standard of their own organizational measures of security. How to run through a checklist of your data security procedures. You start, I think, when we started earlier in looking at this system as a whole and looking at compliance as a whole, you do the data mapping. You undertake a risk assessment. You look at your documents and see if they are what they should be. You appoint an accountable individual. That might be the data processing, the data protection officer, or whoever it is that is running the thing, or it might be the IT side. You carry out training and communication, make sure everyone understands the way the business approaches security and what role they have to play in that. Consider encryption and other technical measures. Obviously, those are very much common, but they have to be adhered to. If unencrypted data gets out in a breach, then that is treated very seriously in terms of consequences. Look at your third-party arrangements. You were just saying about the data processor. You've got to look at the fact that you are handing data to people who might not be up to the level that your compliance and system safety. Plan for business continuity and disaster recovery. That's been going on for a long time, but it's changing, isn't it, in nature as new threats emerge. Plan for a breach. Be ready. Backup and so on. Keep functioning. Part of the of a data breach might be that it stops you from carrying on your activities. So you've got to. The requirement is that you've got to be able to go on processing the same information, and so doing testing, evaluating, checking, getting procedures in place. There are things like cyber essentials, those kind of validation processes. They show that an organization has followed certain security procedures and so on. Data breach reporting, just to finish off with, not all data breaches need to be reported. It depends on the consequence and the risk that they pose. But you've got to be alert to it, and as you find out, you've got to make the assessment of should we report. If you should report, you should do so within 72 hours. Next one. And document-wise, well, the ICO does a guide on how to deal with cybersecurity incidents, but you should be pre-prepared, I think, in terms of having information or knowing how to communicate, I should say, a breach. What are you going to say to people? Who are you going to send that to, and so on. So that, and 10 minutes left for questions. That is the presentation. The handout will follow, and if we can get some feedback on what people think and what they would like in terms of compliance services, we'd be very pleased to start to create some kind of offering. Discounted, of course, to people who sat through the GDPR presentation, and we would be very pleased to help put some of this into operation in practice. So,
thank you very much, Michael.
Thanks, Helen.
Goodness me. Can I ask if you take the screen down, please? Lovely. And can we see everyone?
Yep.
Gallery. And I'm going to ask, so informative that, and we'll all be really looking forward to the document you're going to send us next week. I think everyone will be printing it out and it'll become the new, I'm sure, yes, we'll just be using it. I was amazed, and it's so complicated. Now, can I see any yellow hands? Well, I've got a real live hand. Rebecca, you're on mute.
Hello. I didn't see a hand to be able to raise,
Oh,
actually.
sorry.
But I don't know if there is one or not, but I did look. I was just wondering, thank you so much, by the way, Michael. That was great. And I just really want to understand, because I'm in the process of sort of finalizing my website and things like that. And I wondered whether you have any knowledge about the kind of privacy policy, GDPR policies that we have to sort of put on there. And if so, where we might get something like that. Are the templates you sort of find online, are they sort of reliable, robust? You know, what sort of thing should a new business do to kind of minimize cost, but maximize, you know, our trust with our clients and things like that?
Yes, well, I would say get advice and get someone to assist you. I don't think it'd be terribly expensive because it's not a huge process, but it is important to understand, what the purpose of the processing is and what interaction there is through the website, what the data protection issues are. Your parents' companion, so you've got an age issue here, haven't you? You've got children. So you need to give some thought to that. Yes, you can take things off the internet if you think that they fit with your requirements, but if you want to show that you've done the job properly, then I think taking some advice and getting someone to help you draft it or draft it for you, it's, as I say, these are not terribly complex. Once the drafts person has got it clear what it is that they're being asked to address, what are you going to do? You're just going to explain what's going on, what is the data that is being processed, and what's going to happen to it. So I think data, and assuming that it's only website. I mean, what it depends on the organisation as a whole. I mean, it may be that you need to give, you have any employees, you may need to give them privacy notices, and so on. If you've got parents, then again, you're dealing with the information of their children, and I think you need to give specific attention to that.
Okay. Thank you so much, Michael. Thank you.
Rebecca. Any more questions? Hans? Malcolm?
Hi there. Thank you very much for that. It's very informative. I run an estate agency business, and I remember when GDPR was first introduced, and we all panicked and ran around and saw policies in place, and then promptly forgot most of what we were supposed to be doing. However, we have made attempts to sort of keep the staff on board and train them. I have, over the law, since it was introduced, I think I've had 3 SARS requests come into our company. They've all been used as a stick to beat us with by parties that may not be the direct contractors within our agreements, but yeah, I'm thinking of a case in point, which is a divorce case. Court insisted on the house being sold. One of the parties didn't want it. Caused loads and loads of fuss, and in the end decided that they would just give us a little bit of a kick in by asking a SARS request. It took us probably almost a week's worth of man days to pull all the information together, redact all the documents. And so what we ended up with, thousands of sheets of paper, all redacted, all re-photocopied. Is there any way around that? I mean, were we being overboard with our response? Or is that just the way life is?
I'm afraid I think that is exactly what it's like. There isn't a way around. I think you did very well, but I mean, you sort of emphasised and underlined what I was saying. I didn't want to overstate it, but I've been involved in really big subject access request responses, and it's taken days and days. If you've done it for yourself, you could see exactly why a subject access request would be made in that situation. There's a divorce going on. You're, talking to one of the parties. That party might be divulging things to you that they do not want the other party to know, but it's not protected, so they're entitled to see it. Puts you in an incredibly difficult position. You get a lot of this with accountants,
Yeah.
not protected by privileged information. So, there's a financial dispute going on between two parties. The accountant might be giving advice to one of them, which that party doesn't want the other to know. It's open house, and I think there is. I think you've got to try and think in advance of the best way to do it and to document it. So you say, we're going to search this. These are our systems. We're going to search this. And we've done the search. What we're going to do is we're going to use the name of the person and we're going to use their initials and something else.
Exactly.
So do the methodology, and then get on and get it done. And failing to do it, you're going to get a lot of aggro, and so you better get it out of the way. But you got it right, I think.
Well, word of warning to everyone anyway, make sure you've got someone on hand to be able to spend the time on it.
Very much, very time consuming.
Yeah.
Mm-hmm.
Thank you.
Well, thank you, Malcolm. And keep our fingers crossed it won't happen again to you. Any more questions? Oh, let's go to Daniel, then Raf.
Hello, everyone. My name's Daniel. I'm from a leisure company. Don't know if you can all hear me. I actually just wanted to echo what Malcolm said. I've been working on, I've been doing the GDPR privacy team for quite a few years now, and I've never actually come across a customer who wanted their data just because they're interested. They only want their data to give us a bit of a kick in. So it's always following a refund, a complaint, an exclusion, something like that. So what we found is to have a really robust retention schedule that you follow, because you only have to provide the data that exists. So if you no longer need the data, and you're no longer processing a particular piece of data, redact it or erase it, and then if a request comes in, you don't have it anymore because you legitimately don't need it, and therefore you don't have to provide it. So that's what's really reduced our staffing power on that's gone into these DSARs.
That sounds very sensible, really sensible. Obviously, you've got to get you justify your retention period, but you look at the data, say, do we need to keep it? Does it serve any purpose? In fact, in many respects, it's a very attractive argument that you're maintaining your data in exactly the right way, not really just purely because you're doing it to avoid subject access requests, but because it is the law that you should not be holding data you don't need. So I think that sounds good. I would endorse that.
Thank you, Daniel. I'm going to take a quick question from Raf and then Sybil, because we're just running just slightly over time. Raf first, then Sybil.
Okay, fine. Michael, that was a superb presentation. Thank you. I suppose one of the questions I have is in part being covered by Daniel about retentions policy. What is considered acceptable? Because obviously I came from a financial institution previously where we were governed by certain probably inappropriate times that things had to be kept for. But now, what is considered acceptable?
I don't think there's a one size fits all, really. I think obviously it depends on what the data is, what is the need to hold it, for what period. So, solicitors, for example, will hold data for at least the statutory limitation period on which someone can bring a claim. That might be the case in financial services industry, other professions. Other data you might not need to hold it at all for very long, because like Daniel was saying, it's a bit of a hostage to fortune to have it for longer than you need if you can be attacked with it. So it's a justification argument, and I think the thing is to put a date on it and to have a policy and to implement it. So you say, we've done this here. We've put on both physical files and on electronic files, there is a date when they're going to be they're going to be removed, and so at least that shows that the retention process is there and is working. But I just thought it was a very astute approach that Daniel took, which is to say, well, there's something in this for us. We ought to get this data out of here.
Okay, then, thank you.
Thank
Cheers.
you. Just for information, if you don't know, he is in the office. I can see that. Raf's the finance director of the chamber.
All right. Thank you, Ralph.
There we go. And Sybil.
Hi, Michael. Thank you for your presentation. So my question is, I use a lot of third-party tools, and I'm sure many others on this call do as well. Tools like Google Drive, for example, MailChimp for storing mailing lists of subscribers, and we're using Zoom right now. So my question is, if one of these platforms got hacked or suffered from a data breach, would the platform be responsible for that, or would we as users or business owners be responsible?
Well, most likely it's the platform. If it's got hacked, then it's a data security breach on its part. The question is, have you done anything wrong in using the platform? If it's a large, reputable, I suppose is the right word to use in connection with Google and all the other, large service providers. I think if you've gone through the process of identifying the people that you're dealing with as being, sufficiently trusted by a sufficient number of people, and there's nothing that you know to the contrary that would suggest you ought not to be using them, then I think it would be hard to see why there would be a case against you personally. Yeah.
Great.
Hope that's helped.
That was a really good question, Sybil, and it's wonderful because I can segue into we have another webinar from the chamber in 2 weeks' time today on the 24th of September, and the subject is third-party risk in cybersecurity.
Yeah.
And it is really, and Brian Altimus is one of our chamber members. He's giving us another update, and it's actually quite frightening, but we mustn't be feared. And I'm going to ask Charlie if you can send everyone a link to the third-party risk, because I think it's going to be I think we need it. So 2 weeks today.
Okay, thank you.
Okay, and one other plug I'm going to give, that we are having office drinks at Grants or solicitors' offices, which are lovely. They look over the Thames in Greenwich. They're lovely, lovely modern offices, which you can see. And that's on Thursday, the 10th of October, between 6 and 8 o'clock. So again, Charlie, if you can send that link out to everyone, and hope to see you there. And I would like to thank you, Michael, very much, for it's been, goodness, really informative. Thank you.
Thank you very
And
much.
thank you, Michael Tobin, the marketing manager at Grantsaw, for doing the slides. You did it brilliantly. Thank you.
Yes. Okay.
Thank you.
Bye-bye, everyone.
Thank you. Bye-bye.
Thank you very much.
Thank you. Thank you, Helen.
Bye.
Bye-bye.
Bye.